191331. Counsel, make your appearances.
Stephanie Banish for the plaintiff, Jose Gutierrez.
Bill Reed for the American Bottling Company and DPS Holdings, Inc. and Keurig Dr. Pepper, Inc., formerly known as Dr. Pepper Snapple Group, Inc.
Okay, and we're on a motion to compel, defendant's motion to compel, is that correct?
Yes, Your Honor.
Okay. I have this pulled up. Give me 1 second. All right, well, why don't we go ahead and start with argument, then I'll try to pull this up.
Judge, essentially, Mr. Gutierrez had worked for the American Bottling Company for several years. He was a truck jockey, which means he moved semi-trucks in the back and loaded trailers on them. Back in 2017, May 30th of 2017, he walked behind a forklift. The forklift backed into him and ran over his foot. We may dispute liability, but it's a non-subscriber claim. Primarily what you hear me today seeking is an answer to force the plaintiffs to respond to contention interrogatories. The Dallas Court of Appeals and In Re Sting Soccer Group, a judge up in Collin County had refused to make a party answer contention interrogatories, overruled the objections, and the Dallas Court of Appeals came back and mandamus the court, basically saying our discovery rules now require people to give their general contentions and state forward the facts. That's primarily what I'm asking the plaintiffs to do. The plaintiff has not deposed the corporate rep. They have deposed the forklift operator, and I have deposed Mr. Gutierrez. So what I'd ask the court to do is, once they depose the corporate rep, that they be required to identify their contention facts. So for example, interrogatory 3 asked them to identify the facts that support their contention that we negligently hired Roy Herrera. That was the forklift operator. Our forklift operator had worked for the company over 14 years, had never had an accident. He knew Mr. Gutierrez, the plaintiff, was friends with the plaintiff. The plaintiff said he was a great forklift operator in his deposition. The interrogatory 8 asked for the facts supporting their contention that the forklift operator was not properly trained. Interrogatory number 12 asked for the general contention facts that go to their claim for gross negligence. There are many like that, but I think once you give us a ruling on those specific ones, Ms. Banish and I can work together to come up with a resolution to work that out.
Okay, I want to make sure I'm looking at kind of the right stuff. So I'm going to go ahead and share a screen with you guys if I can. Having some problems here. Let's see. All right. Well, Miss Banish, if you want to respond.
Okay. Yeah, I think that Bill and I basically reached an agreement on the contingent interrogatories, as he says it. So they ask us to state, or ask Jose to state all facts that support his negligent hiring, gross negligence, et cetera, claims, failure to maintain safe environment, inadequate training claims. And I told him that we needed the corporate rep's deposition and possibly a couple others, maybe the direct supervisor for the forklift driver. And then I had to ask Jose about that. And then we'd be able to supplement with whatever information we get. We may not find that there is evidence of gross negligence, and we may drop that claim, but we just need to explore that further. So I think we're agreed on that. Oh, I can't hear you.
What else do we have?
Your Honor, primarily the second category would be the deposition of Mr. Gutierrez. Mr. Gutierrez, he worked for the American Bottling Company, had two events that made me want to look into it. One, in 2013, he was arrested by the city of Irving and pled guilty to a charge of possession of cocaine. When I tried to ask him questions regarding that during his deposition, it was shut down. Specific questions I think you'll find in the motion, like on page 106 of the PDF, if that makes it quicker, was asking him if he ever used cocaine during the time he worked for the American Bottling Company. Approximately a year and a half after his injury, he was still working for the American Bottling Company. And when he moved a truck in the back, he crashed into another truck. And Dr. Pepper, the American Bottling Company has a mandatory procedure that if you get in an accident, you have to be drug tested. He ran away and refused to be drug tested and told people, I'm not going to take the drug test, I test positive anyway. So during the deposition, when I asked him questions regarding what kind of drugs he was on or using at the time, they refused to answer, which I think is relevant. Now, in his deposition, we brought the charge with us for the cocaine pleading guilty. After he pled guilty, there is a note in the file that is unclear to me that says deferred adjudication, something to that extent, where I thought I should be able to ask him. And then finally, the third thing that deals with the criminal, last year in the fall of 2019, he was arrested by the city of Dallas for domestic violence abuse and was removed from the house for a period of 60 days. He is claiming impairment. He's claiming a personal injury, and he's designated a wife as a witness to his pain and suffering. When I asked what the incident was about, they objected to it and refused. The question for me is it likely to lead to the discovery of admissible evidence? Yes. And then the court can rule on whether it's admissible or not. That's generally the second category.
All right, so let's kind of break this down. So the first issue you're asking for, I guess, is has he ever used illegal drugs? Is that basically it?
I wanted to ask him about his 2013 cocaine conviction while he was working at the American Bottling Company, and determine whether he was using cocaine when he worked for the company. Any use of drugs on or off duty violated our procedure.
So let's kind of break that down. So if any drug result, so this is kind of what's clearly admissible and what's not admissible. Clearly anything admissible, if he was using drugs at the time of this incident, you can ask about that. But let's say in the 72 hours prior to this and any time, I guess 72 hours, and any drug tests that were taken in the week after, you'll be allowed to go into that. Previous convictions you can go into if they're felonies or crimes of moral turpitude in the last 10 years. Does that cover everything you wanted, or is there something else?
The issue, Judge, was when he had his accident, he was tested on that day in May of 2017. It came back negative. The cocaine incident I wanted to ask him for was a felony conviction that he pled guilty to, but on the same report, it says some type of deferred adjudication. So I wanted to ask him questions about that conviction where he pled guilty to, and they refused. And specifically was he using cocaine during the time he worked for American Bottling Company based on his guilty plea to the felony?
Okay, so two different issues there. One, you can go into what did he plead, what was, because all of that's going to go into whether or not that conviction is admissible. So what he pled to, what the result of the plea was, if it was a conviction or a deferred adjudication, how much jail time did he serve, how much time did he serve in prison, any other convictions he had in the last 10 years. You're not going to be able to ask him about drug use at the company. That's not going to be relevant in this lawsuit. It may be in some kind of wrongful termination case, but not in this lawsuit. Did that cover everything?
It does. Then
Banish, did you want to say anything?
I was just going to clarify that I think that you've covered it all. I mean, he was tested on the date of this incident when he was at the hospital, and he tested negative for any drugs or alcohol at that time. And in his deposition, he did testify that he had had, the arrest in 2013 for a charge for cocaine, but it was deferred. So I don't believe there was a final conviction there. I instructed him not to answer detailed questions aside from the stuff the court's already gone over that is typically discoverable on those incidents. And I instructed him not to answer questions related to, had you done any cocaine at all? And, since 2000, it was either 7 or 9 when he started at Dr. Pepper until now, and said that he would just answer regarding any drug use in the relevant time period. So I think the court's already addressed.
I've ruled on everything. Okay. What else?
Well,
What's the next
the
thing?
problem, sorry, I didn't mean to cut you off.
Go ahead.
Where the problem was, Judge, the sheet that was produced from the Dallas County Prosecutor's Office says convicted, guilty plea. Then at the bottom of it, it has a note that makes no sense, deferred adjudication. I was not allowed to ask him what happened or what that meant. I don't know.
Well, I think
The
I can.
guilty plea clearly comes in at trial for a felony conviction.
Well, I would disagree with that for a couple of reasons. One, normally to get a plea and get a deferred adjudication, you have to make a guilty plea, but then the court defers any sentence if you don't get in trouble again. So deferred adjudication would not be a final conviction, but it does necessarily come with a plea of guilty to get the deferred. The second part of that is, it's up to the court's discretion whether a final conviction of a felony or crime of moral turpitude in the last 10 years comes in. But again, he already answered, and you already have evidence of his.
Yeah, I'm not ruling on the admissibility of this. Just, did you instruct him at any time that he could not answer about what his plea was in that case?
I don't believe so, Your Honor. I normally would let him answer, where it was and what the charge was and what the outcome was. And I do believe that he said he thought that he was arrested then, and he was arrested for domestic violence, which I also think was dropped. I don't think there was any conviction on that, and that those were his only arrests in the last 10 years.
And you allowed him to discuss what his plea was and whether or not he successfully completed it or not?
I believe so. Bill, correct me if I'm wrong on that, but I think when I reread that I let him answer those questions.
I had handed him the exhibit and said, is this a copy of your cocaine conviction? Yes. And then she objected. I don't believe that was a final conviction. I believe it was dismissed after deferred adjudication. So that would be a misrepresentation. Question: do you see where it says final pleading guilty? Yes, sir. Is that an accurate statement? And she instructed him not to answer the question at that point. The specific objection reads, objection form, I'll instruct you not to answer. Again, it's a matter of public record, and you clearly looked it up. It was a deferred adjudication. It has been dismissed. There was no final conviction.
What was the question? What was the question again?
Let me show you. It was the criminal county record. Let me show you on page 2. Do you see where it says final pleading guilty? Answer: yes, sir. Question: is that an accurate statement? And then she instructed him not to answer. And
Okay, so that does need to be answered, Ms. Banish. You do need to provide if he whatever his understanding is, if he pled guilty or defer whatever he did, that needs to be provided in your answers to interrogatories.
Okay. What page are you on, Bill? I'm sorry, I was wanting to ask. I was trying to find where you were in the deposition.
it was page 72 of his deposition, line 7. And on the whole motion, it's PDF page 99 of 109.
Okay, I have the actual, like the whole deposition pulled up and then I couldn't find where it was because I wasn't looking at your motion. Okay, I'll keep looking at it, but yes, so then he needs to answer if the charge resolved in deferred adjudication or
Whatever
some
he
other
understands the result of that charge was. That he pled guilty or that he had deferred adjudication or whatever he understands, he needs to provide an answer to that.
Okay, and I believe it was that he pled guilty and it was deferred. Yes.
He just needs to answer that.
Okay.
So medical, personal injury, and claim history. Let me kind of very simply explain what I allow in this in personal injury cases. Any treatment to the same area of the body, which I understand he had a broken foot in this case. Is that right?
A crushed foot, broken ribs, and a hurt left knee.
So he's going to need to provide any evidence or any information about any treatment to the same areas of the body 5 years prior to the accident and post-accident that he received. So, for example, if he had treatment for the same knee 3 years prior to the accident because of a car accident case, he would need to provide the names of the medical providers and any medical records he has, or I guess not for interrogatories, but the names of the medical providers he has for the same areas of the body. Anything that's more than 5 years old or not to the same area of the body, he wouldn't be able to go into. So does that kind of answer that next section?
That does. Probably the last significant, and I'm going to shorten this hearing because there's no reason to keep you on the line all afternoon,
Okay.
is the final thing goes down to this income claim. He has a crushed left foot, and he was working for the American Bottling Company a year and a half after the accident.
Okay.
What's going to come up is that but for him refusing to take the drug test and running away, he would still have a job making the same income. His income had never been impacted by this left foot crush injury on the foot. When he was terminated because he would not take the drug test, I wanted to ask him specifically what was going on at that time, and this is why I believe it's relevant. If they're stipulating he's not making a lost income claim or future earning capacity claim after he had the accident and refused to take the drug test, then it's probably not relevant. But if he's going to come back and say in the future, I have lost wages or earning capacity in the future, then I should be able to develop the evidence to prove that that future loss was caused by drug use and refusing to take the drug test and not had anything to do with his left foot injury.
So let me make sure I understand this. So he continued to work at the company for a year and a half after the accident without missing any time or losing any income?
He missed some time, but we continued to pay him for the year and a half period, yes.
Okay. Ms. Banish, are you making a lost wage claim and a loss for future earning capacity claim?
Yes, Your Honor. We're not claiming that he lost the job at Dr. Pepper because of his injuries, but he may be claiming a future loss of earning capacity because he's always worked as a laborer. And since his foot is really messed up. He was missing some toes. It healed very poorly because he's a diabetic, and they were worried if they did more surgeries, which were necessary, that he would end up losing maybe his whole foot. So they stopped cutting on it. He also does need a left knee surgery, but also the risk of surgery are so high for him that he's elected not to have it. And he is concerned that he's not going to be able to work in the future. But I told Bill, we were talking, before this hearing was scheduled, and then I said I would clarify with Jose how he's doing now and decide if he wants to make that future claim. But he's not claiming, from the time period of missing the job at Dr. Pepper to getting his next job.
And my point simply is this, Your Honor. Had he stayed with the American Bottling Company, we fully accommodated his injury and did everything, and he did not take a pay cut. It's because he left. And the question comes down to, it's a fact issue. If they're going to say he left and not describe it, then I don't think they should be able to say it's impacted his future earning capacity. So if they're going to claim earning capacity in the future at all, I think I should be able to explore what happened. Now, he signed contracts and agreements. Mr. Gutierrez had worked there over 10 years. There's no question that he understood that he could not use drugs or be under the influence of drugs when he operated motor vehicles for the American Bottling Company. And so my position would be, if he was doing that, his future loss was caused by his use of the drugs as opposed to any impairment, because a year and a half later, he didn't have any that contributed to a loss of wages.
Okay. If I may, there's nothing to indicate that he ever had any drug use while he was at Dr. Pepper. And in fact, in his 10 years that he had been there before this happened, he had great reviews. I mean, his supervisors wrote, you know, he doesn't even need to be supervised. He's fantastic. He didn't even get the average or good scores. He got excellent on everything. So by all accounts, he was a fantastic worker. And then when he did get hurt badly, they made him, excuse me. I don't think I have corona, y'all don't worry.
Okay. You are in Colleyville. Did you go out to the Glorias this weekend, or?
No, I was terrified. It was like, no one knows about Colleyville, and now we'll be on the map for violating the stay-at-home orders. No, I've been staying at home, and hopefully don't have it now. Anyway, he went back to work. He was already worried that he wasn't going to be able to keep doing the job that he did, because he was having a lot of problems with his walk and gait and pain. So regardless if he would have lost the job then or at some point, he just may not be able to work and it's something other than a seated job in the future. We're not going to contend. We would be telling the jury that he left Dr. Pepper for unrelated reasons, and that he's continued to work and wants to continue working, but his injuries might get to a point where he's unable to in the future, or has to work in a seated position where he's going to make less money.
Judge, if this may help you, when I deposed Mr. Gutierrez, he said anytime he needed to be off duty that year and a half, they allowed it, they paid him, and they treated him with courtesy and respect. One of the medical records that was used by a doctor he went to after the American Bottling Company is a doctor in Fort Worth by the name of Dr. Dillon. Dr. Dillon wrote in his medical records the reason he was terminated is because they refused to allow him time off to go to the doctor. Mr. Gutierrez, when shown that record, said that's absolutely not true and correct. What I'm trying to do, and I certainly don't want to abuse anyone, that's not my style, is just to make sure I have the evidence that if he's going to come back and say, I have a future earning capacity claim of several $100,000, and I'm able to contest it and explain why he lost his job at Dr. Pepper. Otherwise, it's not effective.
Okay, response?
I mean, the stuff that I just said, I don't know what else really to say to that. He's not claiming loss of earning capacity based upon his leaving Dr. Pepper. He's facing a future loss of earning capacity based on the progression of his injuries.
I hate to, I don't think you can have your cake and eat it too. I understand what you're trying to do, Ms. Banish, but if you're going to try to make some kind of claim, I'm going to allow him to go into at least some discovery about why he left the company. And so I'm not saying it's necessarily admissible, but I'm going to allow discovery on why did he decide to leave the American Bottle Company, just so there's not a mistake with the jury, and we can determine the scope of admissibility later. So a basic statement of why he left the company is okay.
Judge, would that allow me to go into the drug use of that day and refusal to take the
Day
drug?
of what? The day he left, or day?
The day he left of that accident, yes. He crashed the truck, got out of the truck, and left, and told people, I'm not taking the drug test because I would test positive anyway. What the evidence is actually going to show is I wrote Miss Benesh a letter saying this accident happened today. If you'll bring him back and give him a drug test, we'll allow him to come back to work. But he refused to do it.
Ms. Banish, if it's true that he failed because, or he left the company because he had a failed drug, or he was worried he was going to fail a drug test, you would need to say that. You don't need to go into anything besides that.
Okay, I think that was a statement that I was already given, was that he left after the wreck because he would not pass a drug test, and did not say that for cocaine reasons. He said he was on a lot of prescription medications and was concerned about that. I think all the cocaine stuff is coming from the one cocaine arrest he had in 2013, but I'm not aware of any dirty drug test at any time or any other criminal convictions against him, or any drug convictions.
Did she already give that answer, Mr. Reed?
I don't specifically recall, but if she'll stipulate he refused to take the drug test because he thought he would test positive, I'm good with it. But I wanted to make one more point, because we were very clear in our letter to Miss Banish the day it happened. If the medication in his body was from the prescription that was given to him because of his foot injury, we would not terminate it or hold him against him. We specifically said that.
Ms. Banish, if you...
Oh, it's muted. I can't hear. I can't hear, Jeff.
Audibly.
I can't hear.
Can you hear me now?
Yes, sorry.
Okay, sorry. So you kind of can't have it both ways. If you say we left the company because we thought we would fail a drug test after an accident, and you leave it at that, that'll be it. But if you go on to say because of prescription drugs, or he was taking too many prescription drugs, or you try to justify it in that way, then he's going to be able to go into what drugs your client was actually on at the time of the accident. You kind of can't have it both ways.
Okay. Yeah, and I don't,
sense?
well, and I'll double check with him, but I recall that I don't think he was on any drugs at the time of the accident, but was worried that he had in his system for a drug test, possibly from a previous time.
Just be aware that if you make the statement that it was because of prescription drugs, then he's going to be able to go into what drugs he was on at the time of the accident. If you just leave it as, I thought I was going to fail a drug test and not go any farther, then I'm not going to let him go into that. Does that make sense?
Yes. Thank you, Your Honor.
All right, guys, anything else?
One final thing. You
said that last time. I just want to point that out, Mr. Reed. You said one final thing. So, okay, so this is going to be the final thing. So, Mr. Reed, make sure this is truly the final thing.
Yes, sir. I have asked for Mr. Gutierrez's tax returns. They've objected to it. He is making a lost wage claim. I do have the W-2s when he worked at the American Bottling Company, but I don't have what his wages and things have been since then.
You're going to need to provide W-2s of anything he's had since the accident, Ms. Banish, but nothing else, just W-2s or 1099s if he didn't have W-2s.
Okay. Yes,
All
Your
right.
Honor.
Guys, you be safe. Ms. Banish, I hope you you don't go out too much out there in Colleyville. I don't know that it's safe yet. And you guys have a great day. Mr. Reed, you need to prepare an order on all my rulings today. Them to Ms. Banish as soon as possible, and then submit them to me, hopefully as an agreed as to form order. Okay.
Thank you, Your Honor. We will.
All right. Thank you, guys. You have a great day.
You too. All right. Bye-bye. How do I get out?